Today's webinar will be on the Chinese privacy law, that is the PIPL, the Personal Information Protection Law. And today with me, we have Mr. Om Prakash from Sirion Labs. So, first of all, about us, Saro, what does Saro do? So, Saro Consulting is a privacy focused boutique firm where we help our clients set up their privacy programs. I myself am a director of privacy technology. I lead the wing which helps in tool implementation. Whether it's OneTrust, Big ID, Xtero, you name the tool, and we have the capabilities where we can help the clients first choose the tool and implement it. I also have Mr. Om Prakash with me. Mr. Om Prakash is a senior manager in Sirion Labs. Sirion Labs is a software company which mostly deals in helping clients manage their enterprise contracts. Over to you, sir.
Thank you very much, Rohit, and a very good morning to you, and good afternoon to the folks who had joined from India. I am really pleased to be here. Thank you for having me here. I'm basically comes from a IT background, and I moved to the compliance side. I'm fellow in information privacy. I had done a few more certification which are required, or which are, you can say, the top notch certification in the privacy field. At this point of time, I'm handling the privacy data privacy team in Sirion, and we are creating a data privacy framework and getting that implemented. And I have more than, you can say, 5 years of experience implementing or creating data privacy framework and implementing these, having exposure to more than 25 different privacy laws. And yes, PIPL is also one of them. Thank you very much having me here, Rohit.
Thank you, sir, for the introduction. Moving forward, first of all, I would like to begin with a disclaimer that this session is purely for an educational purpose. The people involved in this session do not represent the views of the organizations they work in. As for the contents for today, we will be beginning with a slight introduction about the PIPL. Then we'll discuss the legal basis of processing, the data subject rights, um, the third party processing, where a company needs to send out data and share data with the various vendors. We'll also be discussing about the processing of sensitive data, the penalties associated even when there is non-compliance. It can be related to um, not putting enough controls, security controls, or not fulfilling a data subject right. Then, before winding up, we'll revise through the important concepts, important definitions for the PIPL so that you can take it forward. And we'll also discuss some of the compliance strategies that you can apply in your organization. Personal Information Protection Law is a Chinese privacy law that came into force in 2021. It is seen as an extension of data security law, which mostly deals with how the data has to be stored, protected, transferred within China. But I would like your view on this, sir.
Yeah, thank you, Rohit. Basically, they have, tries of different laws. One is cyber security law, another one is data security law, CSL, DSL, and then this PIPL. So this, all the tries is basically helping them in handling each and every type of the data. So as you shared that it implemented from November 1st and came in this 2020. So this has, different, I think more than 13 8 chapters, different chapters, having all the information very similar to GDPR, but few things are different. That we will be definitely going to discuss further on when we'll be moving ahead in this presentation. So few things which are different from GDPR and which hampers when cross-border data transfer. We will be discussing that later on within the slide.
So we'll be discussing a lot on the differences with the GDPR, but in many aspects, the law is very similar to it, especially with respect to the data subject rights. But there are a few differences especially when it comes to how the data has to be handled. And one major difference that we see in privacy laws around the world is the concept of data localization. Whether they promote data localization, or I would say enforce data localization, or they allow the data to be stored anywhere. I have not answered the question where whether data localization has been enforced in PIPL. That we'll discuss in the later slides. The legal basis of processing, even if you have collected the data from a data subject, then on what basis are you allowed to process that, store that? So I would like to have your views on this.
Well, most of the things, again, as we stated in the beginning, that most of the things are similar to GDPR. Significant change we see, what we see here is legitimate interest. They have dropped this legal way to process this data. Otherwise, having the consent or contract or having human resource management, uh, statutory duties, responsibilities, or statutory obligations that are another legal basis for processing of the data. Then sudden public health incidents, like COVID was there in 2020, for basically just public health incidents, and where the Chinese this government need to protect lives and health and property basically of their citizens, and that type of emergency condition, the data could be processed without any issue. Then for they have taken this news reporting and public opinion, taking the public opinion, supervision of different rights of these individuals, that type of activities which are related to public interest basically also could be used as a legal basis. And when PII is publicly available, that is self-explanatory. That is also a way you can process personal data legally.
As you rightly specified, so one of the major observations that can be made here is if you refer to Article 6 of GDPR, on the sixth uh, legal basis of processing, you will see legitimate interest mentioned there. And in today's world, you will see a lot of companies depending on that to process uh, data subjects data. But here we see that China has dropped that. Instead, it has very specifically specified that all things have to be either be in a public interest, or it should be bound by contract, or our favorite, it has to have a consent associated. Moving forward, we come to the data subject rights. Here also we see that there is a lot of similarity with the GDPR. But Mr. Om, do you think is there any difference or anything that we should highlight?
Well, before that, I would like to say one more thing, which I think we could have discussed in the beginning. When we talk about sensitive personal data, they have added one term which they have not clearly defined anywhere, that is spatially designated status. So yes, you have lots of sensitive personal data when you process, and this is the spatially designated status has not defined. So again, a gray area. But yes, when we talk about data subjects' rights, I would say not there is no major difference. Almost similar things which they have chosen for this. Uh, this again, right to correct and supplement. Again, this supplement, I think I have not find anything related or surrounding this supplement. What they want to have here, what they want to say in this area. So that is one thing which I would say that need more clarification, and that is not available publicly. What they want to supplement here.
Yes, so it can be they want, in case there has to be additional information that is to be given. But again, it would come under the purview of correction of the personal data that is already stored. But yeah, some more clarity is needed. And one more thing that I have observed is in the Chinese law that they have specified that the data subject requests have to be fulfilled in a timely manner. They have not explicitly given the timeline. in which it has to be fulfilled. So they have specified that in case a company denies or an organization denies a data subject right, they can be penalized. But they have not specified what is the nature of denial. Is it like explicit denial, or you receive a request and you do not act on it?
Yeah, absolutely.
Then we also see the right for the deceased. And when we compare it to the Indian law, we'll feel that India has not added a law for the deceased, but that is covered under the right to nominate people. So in case somebody is deceased, they can it can be observed, or I would say it can be taken for granted that they have the right to nominate people. And GDPR differs in that because GDPR mostly covers the living beings and they do not have an explicit right for the deceased. I think so, sir. This should be part of a data subject right, because once a person dies, that does not mean that his data is disconnected from the family. Because privacy law is just my opinion, just my view. But since privacy laws are people laws. They're not there for the governments. They're not there for the organizations. They are there for the people, to help people get more control of the data that they are sharing. So even if a person is deceased, this data is related to the family. So I think this should be a law that should be there. Of course, the definition can vary, but people should be allowed to nominate if they are incapable of exercising data subject rights, because not all the people in the world are know of uh, how I would say digital mobiles or digital interfaces available. But if they nominate people, that would make things easier for them.
Absolutely. And I've seen in most of privacy law in Western countries, they don't talk about these individuals, but in Asian countries, like I think I have read in some other law also, along with this DPDPA and this PIPL, some other law, Asian law also talks about the rights of these individuals. Because we in this part of the world, we definitely care about every individual living being or disease individuals.
So I'll move to the next slide. That would be third party processing. So would you like to add anything here?
Well, when we talk about third party processing, like the first thing is that they have different terms for controller and processor. So interested person or party is basically the third party or processor in terms of GDPR, if we talk about. So yes, few duties are carried forward to the processors, and um, basically it's a controller's duty most of the time, like having the contract with them where data will be processed, what will be the retention period, what will going to happen after the termination or expiry of the contract. So all these things a controller need to put in the contract, and both the party need to sign this, and controller basically need to do this vendor assessment and that type of things. And most of the things they are responsible, but I'm not saying that processor is not responsible. Processor is also responsible for the task or for the reasons where they are if anything hampers because of the processor. So these things carried forward to the processor. In the same level as controller, they need to also formulate an internal management structure for handling the personal data. So that type of requirement are definitely carried forward to processor as well, or third party, if we say here, interested party.